On the morning of July 11, 2025, 39-year-old Eric Littleton walked into the 34th District Court in Romulus, Michigan, facing a trio of serious felony charges. What should have been a routine preliminary examination hearing instead exploded into one of the most dramatic courtroom confrontations you'll ever see, not because of the defendant, but because of the attorney entrusted with defending him. The Judge Brian Oakley blew up on the defense lawyer for neglecting his client. We're about to unpack exactly what went wrong, when it went wrong, and the explosive consequences. This is not just a courtroom showdown, it's a cautionary tale about the professional duties of counsel and the unyielding power of the bench.
On July 11, 2025, 39-year-old Eric Littleton was arraigned in the 34th District Court in Romulus, Michigan on 3 felony charges of first-degree criminal sexual conduct causing personal injury, third-degree criminal sexual conduct through force or coercion, and larceny in a building. A so-called preliminary examination was set for July 30th, 2025 in the courtroom of Judge Brian Oakley.
The arrangement and the significance. On that date in July, Littleton was formally arraigned on 3 felony counts: first-degree criminal conduct causing personal injury, third-degree criminal conduct through force or coercion, and larceny in a building. The hearing had been set for July 30, 2025, as the preliminary examination in the 34th District Court. This portion of the process in Michigan is crucial. It is the hearing held in a district court after arraignment in felony cases to determine whether there is probable cause to believe the defendant committed the crime. If the judge finds probable cause, the case is bound over to the circuit court for trial. The proceeding thus forms the gateway between lesser and greater court, and an attorney's presence and preparation are vital. The first signs of trouble. The day of the hearing showed immediate red flags. The prosecutor began the proceeding by announcing a witness who had flown in from abroad for the hearing. The judge asked the defense, "Are we ready to go?" The appointed counsel did not appear. Instead, Farage stood in. The judge asked simple, direct questions. "When did you talk to him and realize you had those problems?" "I asked you a direct question, you can't answer it." Farage explained she had had difficulty communicating with her client and that the previous counsel was unavailable. The judge retorted sharply, "If this was a problem you could have told them about a week ago, we could have avoided that." Without skipping a beat, the judge ordered, "Schedule a show cause for Attorney King for contempt of court." He pressed, "Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?" At that moment, the hearing shifted from a legal formality to a full-blown crisis of counsel competence and client protection. The courtroom atmosphere turned tense, not due to the charges, but due to the attorney's apparent absence and lack of preparation.
All right, ladies, we ready to go?
Yes, Judge, we're ready to go, and I have a complaining witness who flew in from out of the country to be here today.
All right, put her on the stand.
Your Honor, okay. Mr. Littleton, to refer to competency, at this time, the defense counsel is adamant that Mr. Littleton is no way understanding the nature or the object of the proceeding and cannot. But he is not fully aware, Your Honor, when I try to ask him or explain to him that I'm his attorney. He doesn't.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So it was the first time that it was a little off. If Your Honor was, I'm not sure if Your Honor was the judge that at that time.
Was not.
Statement saying that I didn't think anything.
Counsel, my question was a simple one. When did you know you had this problem?
So I'm telling you it's a compounded issue, Your Honor. It wasn't just the first time, it was the second time also.
Denied. Denied. Twice I've asked you a direct question, you can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today.
this one is
I didn't ask for an argument, counsel. I just told you my decision.
going to be completely, I think to be ready and effectively upon Mr. Littleton had no opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Ms.
So schedule a show cause for Attorney King for contempt of court.
Attorney neglect and ethical failures. What became clear almost immediately was that Littleton's attorney, King, had failed to meet fundamental professional obligations. The prosecutor revealed she had repeatedly attempted to reach King to determine if he intended to raise a competency issue with Littleton, but he did not respond. She testified that she had organized a witness flown in from overseas, indicating serious preparation, yet had not heard back from the attorney until 8:30 a.m. on the morning of the hearing, a day he was required to appear. Under the Michigan Rules of Professional Conduct, attorneys have the following duties. Rule 1.1. Competence. A lawyer shall provide competent representation to a client. Rule 1.3. Diligence. A lawyer shall act with reasonable diligence and promptness. Rule 1.4. Communication. A lawyer shall explain matters to the extent reasonably necessary to permit the client to make informed decisions. Here, King's absence, failure to meet with his client, and failure to be properly present at a key proceeding could be viewed as violations of all three. The judge took note. You guys can take Mr. Littleton back into lock. Did you tell her what happened? I did not. If I find the attorney in contempt, I'm going to charge him for your costs. The prosecutor apologized to the complaining witness, stating, I want to acknowledge the system is not treating you well. This is not simply a delay, it is a breach of the core relationship between attorney and client. The case illustrates how an attorney's neglect can ripple outward, undermining a defendant's rights, delaying justice, and provoking judicial retaliation. Judge Oakley's explosive intervention. Judge Oakley's reaction was immediate, forceful, and rare. He made it clear he was fed up. We've got attorneys that show up the day of the exam, having never spoken to their defendant, day in, day out. Your office is disrespecting the Wayne County bench.
Here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled, that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench.
The judge's tone shifted from exasperation to command. He ordered a show cause hearing for contempt, told the attorney to bring a toothbrush when he came to court next, implying potential jail time.
I told Mr. King that we would address the, because to be fair, Judge,
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Clear? Make sure he brings a toothbrush when he comes for his show cause.
And suspended the examination rather than risk proceeding without proper counsel. He said, the court doesn't have its authority through personal authority, but through the set law. With that, he directed that despite Littleton's objections and counsel's excuses, the hearing would not proceed without the proper lawyer. He ordered, just podium, bring your complaint in, we're not taking testimony. Did you tell her what happened? I did not. If I find the attorney in contempt, I'm going to charge him for your costs. The message to the bench, defense bar, and public was unmistakable. The court will not tolerate attorney neglect when a defendant's rights hang in the balance. Client competency and delayed justice. Beneath the attorney's failure to appear lay an even deeper concern: Eric Littleton's mental competency. Substitute counsel Sahar Faraj hesitated to proceed, expressing doubts about whether her client fully understood the nature and purpose of the hearing. In criminal law, that question is not a technicality. It's a cornerstone of due process. The Supreme Court's ruling in Dusky v. United States, 1960, established that the defendant must have both a rational and factual understanding of the proceedings and be able to assist counsel in his defense. When there's reason to doubt that, the court is obligated to pause everything until mental fitness is verified. Judge Oakley immediately recognized the seriousness of that issue. Faced with a stand-in attorney unfamiliar with the client and an absent lead counsel, he refused to push forward with testimony or cross-examination. To proceed under those conditions would have risked trampling the defendant's constitutional rights. Instead, Oakley halted the examination and ordered a competency evaluation, a move grounded in both Michigan law and common sense. The courtroom, already tense from the attorney's absence, fell silent as the judge made it clear, protecting due process comes before convenience. The consequences were heavy.
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly, with documentation to counsel, what it costs you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs. You understand that? I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because the system is not treating you well.
As Littleton was escorted back into custody, his fate uncertain, the weight of the delay became evident. The case would remain frozen until the competency assessment was completed, weeks, possibly months away. For the defendant, it meant extended incarceration without resolution. For the court, it meant lost time and shaken credibility. And for the attorney, it meant facing potential contempt charges and disciplinary action. One attorney's failure, many systemic lessons. This hearing exposed far more than one lawyer's poor performance. It peeled back the curtain on systemic cracks within the justice system. Every courtroom runs on an unspoken promise that the defense will stand ready, prepared, and loyal to their client's best interests. When that promise breaks, the entire foundation trembles. Attorney James King's absence didn't just inconvenience the court, it stripped his client of representation at a crucial stage, compromising the fairness that every trial anchors. The attorney-client relationship is sacred for a reason. It's not just about legal advice, but about trust, communication, and the assurance that someone is fighting for you when you can't fight for yourself. Judge Oakley's fiery response wasn't anger for its own sake. It was an act of protection. His outburst came from witnessing a defense attorney's neglect threaten a man's constitutional rights. In a system already strained by delays and overwork, Oakley's decision to halt the hearing was a reminder that justice cannot run on shortcuts. It takes courage for a judge to hold an officer of the court accountable in public, but Oakley did so without hesitation, choosing integrity over optics. His actions sent a loud message: the courtroom is not a place for excuses. It's a place where preparation and professionalism are non-negotiable. The ripple effects of that morning extended far beyond one case. A witness had flown in from overseas, only to watch the proceedings collapse before her eyes. Prosecutors lost valuable time, and court staff had to reschedule dockets already overflowing with pending cases. Every wasted hour compounds into days of delay for other defendants waiting for their turn. When one attorney fails, it doesn't just harm one client. It creates a chain reaction that burdens victims, frustrates judges, and erodes public trust in the very system meant to deliver justice. The cost of neglect is measured not only in contempt charges, but in the human toll it inflicts on everyone caught in the process. Even acknowledging that the Neighborhood Defender Service is likely overwhelmed with caseloads, the ethical duties of competence and diligence remain unchanged. A lawyer's oath does not bend under workload. Heavy assignments may explain lapses, but they do not excuse them. As the prosecutor stated bluntly, the impact on the court and the client is the same. The law demands that every person, rich or poor, receive the same standard of representation. When systemic overload becomes an excuse for individual neglect, the entire ideal of equal justice under law begins to crumble. For anyone watching, this case carries a sobering takeaway. If you or someone you know faces charges, don't assume the system will automatically safeguard your rights. Demand accountability. Ask your lawyer hard questions. Have you met with me? Do you know the evidence? Will you be there when it counts? Because if they fail to show up, you don't just lose a hearing, you risk losing your freedom, your credibility, and the faith that justice still works. This wasn't merely a story about a frustrated judge or a negligent attorney. It was a mirror held up to the justice system itself, reflecting how one person's failure can expose a flaw far larger than any single case. The human cost behind legal neglect. When the courtroom doors close and the cameras stop recording, what remains are the lives quietly affected by what happened inside. Behind the formality of case numbers and court transcripts, there are people, defendants, victims, witnesses, and families, all depending on the system to function as it should. In People v. Littleton, that system cracked. The defendant sat in custody, confused and unheard, while a witness who had crossed oceans to testify was dismissed without being allowed to speak. The prosecutor, visibly worn, apologized not as a formality but as a human being acknowledging a failure that wasn't hers. One attorney's absence turned a moment of accountability into a day of emotional and procedural collapse. For Eric Littleton, the cost wasn't abstract. It was time, hope, and uncertainty. Each day that passes waiting for a rescheduled hearing or a competency report adds weight to the presumption of innocence. The Constitution promises that justice will be fair and timely, but timely begins to fade when missteps compound. For the victims, that same delay reopens wounds, forcing them to relive trauma without closure. They prepare, they testify, and then they wait again. For witnesses, the system's inefficiency sends a damaging message that their sacrifices mean little when professionalism falters. The emotional toll extends to the courtroom staff as well. Clerks, bailiffs, and interpreters, all working within schedules that are stretched thin by cases like this. Each delay ripples through a calendar that has no space left for mistakes. In Michigan's already crowded court system, even a single botched hearing can set off a chain reaction affecting dozens of other cases. The burden is invisible but real, measured not just in hours lost, but in faith eroded. The very people who rely on the court to protect them begin to question whether it's capable of protecting anyone at all. This is the quiet tragedy of legal neglect. Its victims rarely have headlines, only consequences. The attorney who fails to show up moves on to his next disciplinary hearing or reprimand. But the people left behind, defendants who remain jailed, victims who lose faith, witnesses who feel dismissed, live with the fallout. Each failure of representation chips away at the idea that the justice system is built for everyone. And when faith in that system weakens, justice itself becomes harder to recognize. Restoring trust in the justice system. Accountability is where justice begins. Judge Oakley's decision wasn't punishment, it was principle. His message echoed through the courtroom. A lawyer's duty to their client is not optional, and absence is never excusable. Integrity still matters. But one act of accountability isn't enough. Public defenders are drowning in cases, and when the system overloads, fairness collapses. Reform isn't about blame, it's about balance. Investing in defenders means investing in justice itself. True reform starts with conscience. A missed hearing isn't paperwork, it's a life delayed. Lawyers must see clients as people, not files. Technology can assist, But trust isn't digital, it's human. It lives in judges who act, attorneys who care, and citizens who demand better. The Littleton hearing will fade from headlines, but its lesson endures. Justice isn't restored by policy. It's rebuilt day by day through integrity and presence. What this means for you: this case isn't just about one attorney, one defendant, or one angry judge. It's about a system that touches real lives every single day. For most defendants who can't afford private lawyers, their fate rests entirely in the hands of public defenders. When those lawyers fail to prepare, communicate, or even show up, it's not just a mistake, it's the collapse of their only defense. The courtroom stops being a place of truth and becomes a fight for survival. What happened in Judge Oakley's courtroom is a reminder that justice doesn't depend on laws alone. It depends on people doing their jobs with integrity. Judges, prosecutors, and defense attorneys each hold a piece of that balance. When one fails, someone's future hangs in the balance. The outrage from the bench wasn't about ego, it was about accountability. A call to every lawyer: show up, do your duty, respect the process. But it's also a call to the public. Don't assume the system will protect you. Ask questions. Make sure your lawyer knows your case, understands your story, and stands ready when it counts. Because justice isn't automatic, it demands vigilance. And if the system can fail one person this visibly, what happens to the ones no one's watching? What began as an ordinary preliminary examination in a Michigan district court became a masterclass in courtroom accountability. The judge's anger was not about drama, it was about duty unfulfilled. The attorney's neglect may seem like a one-off incident, but the implications are vast. Legal preparation is not optional. A defendant cannot rely on hope, social media tips, or last-minute appearances. It relies on competent counsel. So ask yourself, would my attorney walk into a key hearing unprepared? Have I been told I'll get back to you more than I met with you? Because when the client is neglected, the entire system feels the pain. Thank you for watching. If you found this breakdown helpful, subscribe, hit the notification bell, and stay with us for our next courtroom dissection, where we go beyond the soundbite and into the strategy, psychology, and law behind every word uttered in court. And here's a question for you. If you were in court and your defense attorney failed to show up, what would you do next? Let us know in the comments below.